They're nice.
Yes, or there's so much wrong.
Can I just say that
somebody said that when you look at that's not a problem. I didn't even look at back well, you told me what your intent was, so I knew because I knew what you were trying Well, yeah, I mean, it's kind of like a Texas bill where it's just a felony. Most of the time, if you look at something, it's so now that this charge goes down to the hot dogs, I don't charge them something. It's the same sort of thing. It's a child. I don't know. Yeah. You're selling it's trafficking anytime a person yeah, victim and you say they've been the victim and the perpetrator. I'm saying it's good relations.
This become the language that I think here I guess
Yeah, we have a lot of, we have some show up to purchase our. And their goal was to purchase this. This actually
He's got an amendment now.
We'll just take them as they come.
Gensler has an amendment. 78.
Where's my pad?
It's on that side right there. Love it.
I'll come down to this. I think it was that they would raise the weekends indigent from 70 to 130.
Let's see. All right, we ready? David? All right, ladies and gentlemen. Hey. Folks, can y'all hear me? Can y'all hear me? All right, yeah, no kidding. All right, ladies and gentlemen, let me get your attention if I could. Thanks. I like it here, it's sort of cozy, don't you think? All right, that was a unanimity of no. This is the first meeting of the House Judiciary Committee. It is rather symbolic that it's Valentine's Day. And I would like to wish each and every one of you a happy Valentine's, and I hope that we keep this spirit of love and camaraderie going throughout the balance of the session. So I guess that remains to be seen. We have Ray Hawthorne back. Where's Ray? Where are you? Ray's back. He's our analyst. We're glad to have Ray back. Amia Agee, where's Amia?
She's making copies.
She is making copies, but she is our intern. We're also very, very happy to have her with us. Also glad, I want y'all to meet, if you do not know a friend of mine, Judge Chad Woodruff. Judge Woodruff, stand up, Judge Woodruff, for me. Judge Woodruff is a presiding circuit judge from Talladega. And we're certainly glad to have him. Ontario, what were you going to say?
One of my favorite judges.
One of his favorite judges.
Absolutely.
That means he has something pending. That means he has something pending. Okay. Folks, we've got 10 bills today. We've got some a few amendments, but not a lot. Some of these bills are things that we've actually taken up last year, got out of our committee, got to the House. Some of them made it out of the House, some of them did not. But nevertheless, we put them back on here. I want you to understand something. There's been a change in the way LSA does business, and I want to bring this to your attention because it's something that we're going to deal with. House Rule 75.1 prohibits committee clerks from accepting amendments or substitutes from any individual other than a member of the House, Senate, or legislative staffer, which obviously includes an LSA employee. Unless those are authorized by the member to submit to the committee, and you will have to deal with that with LSA. We can still do handwritten amendments here if we need to. However, those cause some problems because when we get a handwritten amendment, Brandy has to take that, get it into the proper format, and get it submitted. So what I'm going to ask you to try to do to the best of your ability, and I realize we run this thing week at a time, is to get these amendments if you have them. You know, we try to get these bills out of here on the listing out of here on Thursday or Friday. And I would ask that you look at them. If you have an amendment, please get it done, get it to us. It'll just work smoother if we get those prior to 1 o'clock on the day we have the 1:30 meeting. Okay? Thank y'all. I appreciate your consideration in doing that. Do any of the members y'all have anything you want to say before we get going?
Roll Tide.
Okay, so we're adjourned.
All that she does for this.
No, we genuinely could not.
We're just putting up with you, Judge.
Yes, that's true. And the honorable gentleman to her immediate right. All right, we're going to start these bills. We got several, and the first one is Representative Pringle. Representative Pringle's bill is one that we actually got through, and so, I don't know, somehow it got messed up. So Representative Pringle, go ahead and tell us about it, and let's see what we can do.
Thank you, Mr. Chairman. Ladies and gentlemen, this bill came through last year. It's very personal to me, and I'm sure it's going to be very personal for many people in our communities. The scourge of fentanyl is killing our children, is killing our family members, is killing people every day in this state, in this country. And all this bill simply says is if you sell or give a controlled substance to somebody, and you're not a doctor or pharmacist, if you're a drug dealer, and you sell or give drugs to somebody, and it kills them because of fentanyl, we can charge you with manslaughter.
And Mr. Pringle, this is what we got through this last year, didn't we?
Yes.
Got out of the House, got out of the Senate, somehow
What happened was, I accepted, in conference committee, Senator Smitherman had an amendment, a conference committee change that made it track Representative Simpson's other fentanyl bill. It says fentanyl or its derivatives, and that conference committee report got messed up and it killed the bill.
Okay, I will accept a motion for favorable. We got a motion for, you got a question or what? You go ahead.
I mean, it wouldn't be right if I didn't have a question on the first meeting.
Yes, sir.
But no, there was also another amendment that was offered and accepted in the session last year that added the word knowingly to this legislation. And it is on this bill. It is stricken through. Are you willing to accept that amendment to restore that language?
That bill, the way this bill is currently written, it tracks federal law. And if you put the word knowingly, I'm not a lawyer, but I could get every drug dealer off. We can never charge a drug dealer because then all the drug dealer has to say is, I didn't know it had fentanyl in it. I'm innocent. I didn't know it. So you can't charge me with selling drugs and killing people.
I mean, that's a burden that we carry in every single prosecution on every single criminal charge that goes into court. That's really a distinction. Doesn't draw a difference. And the reason that the knowingly language is important is because not everybody's a drug dealer. Some people are addicted to a substance and they're using a substance together. Two people, and the two people that are abusing the same drug, one gives that to the other. Both addicted to a substance, but that person could be charged and convicted of manslaughter. And that was part of the reason that was introduced.
And I didn't realize the hole it was going to put in the bill so you couldn't prosecute. Here's a perfect example for you, Representative. You and your buddy go out and you get drunk as rats. And you get in a car, and you're driving 100 miles an hour down the road, and you wrap that car around a tree, and you kill your friend. And you can go to the judge and say, I didn't know driving 100 miles an hour and wrecking would kill my friend. You can't charge me with manslaughter.
That's not true.
It's the same exact thing. You're negligent.
That is absolutely 100% false. It's not just manslaughter, it's murder. That's what we charge now. So, no.
You killed somebody.
The driver of a vehicle, even if that person doesn't get hurt, can be charged with assault. So no,
But if you give drugs to somebody and kill them, why do you think they should not be able to be charged with manslaughter?
I didn't use that example. That was yours.
No, you said if two people are using a drug and one of them dies and the other one, we can't charge the other one?
We didn't. We don't. Matter of fact,
if you're doing illegal drugs and you give illegal drugs to somebody else, and you cause
matter of fact, we created an exception so people who are involved with others who are overdosing can actually call the police or call help to come and help that person so we don't charge them. What your bill will actually do is provide a disincentive and allow somebody to sit there and watch somebody else die because they don't want to be charged with manslaughter.
Because they gave an illegal drug to their friend.
Because they're using an illegal drug with somebody else.
They gave it to their friend and caused their friend's death.
But you said the intent of this bill was to catch drug dealers.
It's people who are selling or giving drugs to people, yes. They're killing people, giving them these drugs laced with fentanyl. Here's what blows my mind. Wrap your mind around this. If the drug dealer is not selling enough of his product, he intentionally adds fentanyl to it to make sure he kills people. Because if it gets out on the street that this particular drug dealer's drug is killing people, the drug addicts want to buy it, so his drug sales go up.
I'm not talking about drug dealers.
That's the people selling fentanyl.
I'm not talking about drug
But
dealers.
you're letting the drug dealers get off the same as anybody else by putting knowingly. Because any drug dealer, whether he mixes the drug or not, is going to say, I didn't know it had fentanyl in it.
And then,
how do I know?
And then we'll take the evidence that's available to us and prove that a drug dealer is in fact a drug dealer and intended to give this. We don't even have to prove. Actually, don't even have to prove intent. It's reckless. So again, what I'm saying,
The District
reason why
Attorneys
we have this.
Association pointed out to me the way this bill is written, it tracks federal law.
Okay.
That knowingly put a problem in the bill. We didn't catch it at first, and it made it almost impossible to prosecute people.
And that's just that's absolutely not true. But what you're basically saying is you would not be willing to accept an amendment to put the bill back to where we passed it.
I think I made a mistake in where that word knowingly was placed in the bill, and it made it so you couldn't prosecute.
But I'm just that's
the truth.
That's not true. It is the truth. It's not true to say that you can't prosecute somebody because you've got a ton of circumstantial evidence, so you'll be able to tell the difference between somebody who's a drug dealer and somebody who's an addict.
Let's do this, Representative. Let's work with the District Attorneys Association, and if that's the case, I'll amend it on the floor again.
That's all I have.
Mr. Chestnut?
Yes. My question on this bill is that he talks about, wanting to go after the drug dealers. The issue with that is you still say furnishes or gives away. So actually 2 friends could be together and a friend could just give a friend it, and then that friend could do 20 years because he gave his friend something that he may have thought was something else, but it was laced with fentanyl.
How do you mistake heroin as maybe something else? Or how do you mistake cocaine or crack cocaine?
I mean, I don't know that.
Drug.
I'm not a user, never been a user, but you may know better than I do. But
if you're using illegal drugs and you give illegal drugs to your friend and you cause your friend's death, I'm sorry, but you need to go to jail. You killed your friend. You gave them drugs that killed them.
Mr. England, back to you.
Just for another point of clarification. In the effort to prosecute this case, you've got to prove the substance anyway.
Well, you pretty much proved it because the person's dead.
No, you haven't. That's why you have to prove it. You have to substantiate. I'll just give you your DUI example. For example, if you're charging somebody with driving under the influence, you actually have to prove whether it was alcohol or a controlled substance or marijuana or some other substance that impairs the ability to drive safely. That's the standard that we already operate under. That's not unique and that's not new. In order to prosecute somebody, you are going to have to prove that the substance used recklessly caused the death. So everything that you're saying here is something that a burden that prosecutors already carry in every case that involves drugs. And also, to take it a step further, you know what burden else they have to carry in every case? They have to prove that they've either sold it, gave it away, or somehow distributed it. They're all elements of the offense. The only thing this language would ask is that we're going to separate the folks that are actually drug dealers with that language from the people who aren't. Who you said is who you're targeting with this particular legislation. And for what it's worth, I agree with you about people who deal fentanyl. But guess what? Under your legislation, they've got to prove that it was fentanyl already.
But the drug dealer can say, I didn't know it had fentanyl in it when I gave it to
Do you know, as a prosecutor, do you know how many people are sitting in jail right now who said the exact same thing you just said? It happens all the time.
Yeah. Well,
not unique.
But
what I'm saying is, for your legislation to actually get to the people that you want to incarcerate and separate them from people who are just addicts, we actually waste time, waste space, waste resources on a 20-year prison system because they're there because they have a drug problem, not because they're drug dealers. You need to put in this legislation that it's knowingly, so you can actually get to the people that you're talking about.
I'm sorry, I just have a problem. If you give somebody a drug and you kill them because it's fentanyl, I don't see the difference between killing somebody in a car wreck or killing somebody by passing fentanyl to them. And if it's your friend and you kill your friend, that's even worse.
Yes, in law school in the first year, when you take criminal law, they teach you that you must have a guilty mind. You have mens rea and you have actus reus, right? Mens rea is the guilty mind, and actus reus is the guilty act. So with this, you're essentially removing the guilty mind, and you're imposing strict liability on any person who just happens to possess fentanyl, whether they know they're possessing it or not. They could have something that they think is an aspirin, and they could pass it to a friend and use it themselves, and they would be charged under this with a felony. And this, the way you're trying to word it, it would be impose strict liability. There would be no mental capacity, no mental intentionality, whether specific or general, to commit this crime. And that's why it's bad in the form that you're presenting it. Will you be open to making it one that will make sense, where you at least, I have no problem with sales. I have no problem with distributes, because that's the way a lot of the drug crimes are written anyway. But when you start talking about gives away, I mean, it's just...
Well, drug dealers give drugs to people to get them hooked. It's the oldest trick in the book. You see them out there giving drugs to young kids, they get them hooked, and they start selling them to them. So that's the reason you put gives away in there. You know as well as I do, you can see those drug dealers sitting on the street corner giving drugs to kids because they want them hooked. You're an attorney. I get charged under this crime. What's the first thing you're going to tell me? Now listen, you just need to plead. You didn't know there was fentanyl in that drug. I know you bought it from a drug cartel, but you have to just say, I didn't know there was fentanyl in it. I just didn't know.
Okay, and in response to you, those are circumstances that clearly lead to the idea that the person had the mens rea to do it. What you just described, those are circumstantial evidence. You don't have to, he doesn't have to say, yeah, I meant to do it. You can look at the circumstances. If I go outside and I see snow on the ground, it's reasonable to believe that it snowed last night, right? So, I mean, I think if you all we're asking you to do is work with the language. This is something that
I told y'all every day. If y'all will work with the District Attorneys Association on the language, and I'll be more than willing to put an amendment on the floor.
Okay. Anything else? Yes, sir, Mr.
I move to give the bill a favorable report.
Second. Okay, there's a motion and a second to give this bill a favorable report. Any further discussion? All in favor, say aye.
Aye.
Any opposed?
No.
Thank you. Favorable
Thank you.
report. Mr. Pringle, some of their comments are good. Let's work with them. Okay? Thank you. Mr. Treadaway.
Chairman, members of the committee, I have a bill before you to bring us all back together. And so, real quick on this, did you get my letter? Did you get the letter from the victim on this bill? Okay. So let me tell you about this real quick. A few months ago, this gentleman came to me. He grew up with my son, been in and out of my house. This was a scout leader. This was a Sunday school teacher that took my children along with his child on outings. And thank God my son was not violated, because I'm standing before you. But this young man is a naval officer. Never went to trial. This young man, stepfather came into his life at 5 years old. He groomed him till he was 10. And over the next 6 years, sodomized and molested him. And it's the first time I was ever asked to personally stand with somebody at the pardon and parole board. And I found out. I wrote a letter first. The governor wrote a letter. And I picked up something on the governor's letter that concerned me. It said, if you allow this pardon, please do not allow this person to come off the sex register. That caught my attention. So I started asking. Found out that if a person gets a pardon for molesting a child, and let me back up, this guy's a naval officer, couldn't go to trial, was postponed multiple times. He agreed to a deal. I've been in law enforcement 31 years. What happened to this child, as long as it happened over, and this guy never served a day in jail. Not a day. Cut a deal
admit to everything he did, pled guilty to these charges. Didn't know that every 2 years he can bring this individual who's now married, still in the military, bring him down here every 2 years and put him before the Parole and Pardon Board. So a couple issues this bill does. The current law is if you serve your full sentence, you can ask for a pardon. If you're a child molester, you can get that pardon under the law if allowed and come off the register. I didn't know in the law here that a child molester cannot get early parole. This bill simply says they can never ask for a pardon. This individual gets a pardon, he clears his record. And nobody can tell me I'm wrong on that up in LSA. That should never happen. He's going to bring them back if we don't do something here. So this bill is real simple. You molest a child, any of these type crimes, Class A felony, no matter how long you serve, you will never be eligible for a pardon. You're not even in current law eligible for a parole. That's what the bill does.
Any questions?
Sir,
Yes, sir. I'm going to bring it up in just a second, but before I do, are there any questions about the substance of this bill? Mr. Treadaway, I got an amendment here that names this bill as Aaron's Law, which I think is the name of the individual that was molested.
It's the naval officer, young man's.
And do you have are you consider that a favorable amendment?
I do.
Then I would offer that amendment. Second. All right. Any discussion on the amendment? All in favor say aye. Aye. All right, so the bill back to you as amended. Is there a motion to give, okay, Mr. Faulkner and Mr. Pettis is a motion, a second. Give this bill a favorable report as amended. Any questions? Okay, all in favor say aye. Aye. Mr. Treadaway, thank you a lot.
Thank you, members of the committee.
Ms. Givens, are you ready?
Yes.
Okay.
Mr. Chairman, committee?
I think we got a couple amendments on yours, do we not?
Yes, sir,
All
we
right,
do.
one of them, okay, go ahead, please, ma'am. Please go ahead and you explain it, and then we'll worry about the amendments in a second.
Okay. This bill is for human trafficking. It's for anyone 18 years old and under. If they are caught trafficking an 18-year-old or under, it's a mandatory life sentence. So we have two amendments. The first amendment is replace line 54 on page 2 with the following. He or she knowingly gives or attempts to give monetary consideration for the sexual transaction or whatever they're.
All right, and ladies and gentlemen, I will offer that amendment. What it does is it simply makes attempting to offer that money the same as having offered it.
Second.
Thank you, Mr. Chestnut. Okay, there's a motion and a second to amend this bill. Is there any discussion on that amendment? Okay, all in favor say aye. Aye. Any opposed? Go ahead, ma'am, please.
Okay, and the next amendment is adding after the word imprisonment on, let me get to my page. Page 3, under E, where it would state, however, if the defendant is 18 years of age or younger, the court shall sentence this defendant as a Class A felony.
Mr. Faulkner, is this your amendment?
Yeah, I can add something to that. So looking at the constitutional, making this more bulletproof constitutionally, to sentence a minor with life imprisonment without any discretion on that is, we believe, could be challenged. And so we've added this amendment that if the trafficker, the defendant, is a minor, they would stay as a Class A felony as the law is written, even if it's trafficking another minor. But when you get into minors and mandatory life sentences on minors, we believe there'd be a constitutional problem.
Isn't this a problem we had on the capital cases? Thought it was.
Yes.
Okay, is there any questions on that? Do you offer that amendment?
I do offer that.
Is there a second? Mr. Pettis, second. Is there any questions about the amendment?
I have one comment about the amendment. This is real, it's the English teacher coming out in me, but I'm not an English teacher, but maybe somebody in the room is. They can correct me, but I think it should say either Class A felon with no Y or to a Class A felony. Okay, you good with that? Okay.
I mean,
I wrote it in a hurry.
Okay.
Longer pressure to me.
I understand.
And Ms. Altman, we appreciate it because you see very few English scholars sitting around this table. All right, so the amendment would be to make it a Class A felon. All right, go ahead, Mr.
I just want to say, we're on bill number 2 of this year. We've already had a fight about knowingly. We've already called Faulkner not knowing, and we've got a typo. So welcome back to Judiciary. Everybody thought we got along last year? This is fun.
Okie doke. Thank you, sir. There's a motion to give this bill a favorable report as amended 2 times. Any questions or any comments? Sir, all right, I'm sorry. Let's vote on the second amendment. Thank you. All in favor of the second amendment, please say aye. Any opposed? Thank you. All right, now, favorable report is amended, right? Mr. Pettis? Yes. Okay. Thank you. There's a motion to give this bill a favorable report as amended? All in favor, please say aye. Any opposed? Thank you, ma'am. We appreciate it.
Thank you.
Good job. Good job. Welcome to the Judiciary Committee.
Judge, Mr. Chairman, I just want to recognize Jared Hudson and Representative Givens. Thank you for bringing this bill, and Jared Hudson for what your organization does in the area of human trafficking. We appreciate you.
No question about it.
Good afternoon.
Okay, Ms. Givens, I'm sorry, Ms. Halsey, I apologize. I got one.
I've been called worse.
Yes, ma'am. I understand.
Good afternoon. Thank you, Judge Hill and members. I appreciate you guys letting me come before you today. So I'm coming regarding HB 125, which just addresses a matter of concern that really was brought to me by some constituents, and then also in working with ALCAP and the Southern Baptist Convention for Alabama. And essentially this legislation it's prompted by the imperative to really just safeguard our youth when they are targeted for exploitation by a minister, priest, rabbi, bishop, or other recognized member of clergy, occupying positions of trust within the religious institutions. So essentially what it does is it prohibits clergy members from engaging in sexual activity or acts with individuals under the age of 19, irrespective of consent, and provides for penalties. We're also going to have an amendment.
And Mr. Simpson, you got the amendment. Go ahead.
I do. The amendment isn't passed out to you all. This changes the language to track the language currently in the Alabama Rules of Evidence, Rule 505, which is the privilege relating to clergymen. So this just puts the same exact definition as to what a clergy would be regarding this. It's treated the same way under the Rules of Evidence as it would be in the statute.
Yep. Thank you, Mr. Simpson. All right, that's the amendment. That's offered by Mr. Simpson. Is there a second? Thank you. All right, the amendment is offered and second. Are there any questions on the amendment?
Well, I'm sure I do. Hang on. And I guess my question to Mr. Simpson, we talked about this earlier, but so if we're talking about a youth pastor, we think that would, and who is not ordained or licensed, or, not really a traditional pastor, priest, or rabbi, but we think that would fall under commissioned minister?
I would say it would fall under the section part of any person who regularly, as a vocation, devotes a substantial portion of his or her time and abilities to the service of his or her church or religious organization in a position of trust. Okay. I think that catches as a catch-all that catches youth ministers.
Okay, and excludes Sunday school teachers and things of that nature?
I think in the bill as it is currently, if you look at line 57 and line 58 on page 3, on the top of page 3, it includes any staff member or volunteer. We're taking that language out to make sure that this isn't a gigantic catch-all. This is more in line with how the rules of evidence affect. So the youth pastor would qualify because they spend most of their time there. Sunday school teacher that just is a part-time, or does it on their own on Sunday morning, I don't think that would classify.
Thank you.
Did that answer your question, Ms. Owen?
Yes, sir.
Thank you, ma'am. Any further questions? All right, there's a motion to amend this bill. Is there a second to do so?
Second.
Thank you. Okay, that's fine. That's fine. Okay, there's a motion and a second to adopt the amendment. Any further questions? All in favor of the adoption, say aye. Aye. All right, I'll now accept a motion to give this bill a favorable report as amended. Mr. Faulkner and Mr. Betso, okay? Any further questions? Sir? Yes, sir, please.
And maybe I'm just missing it. Youth pastor, 19 years old. Victim or whoever, 17. Would this criminalize that relationship?
So can I bring someone up if they're still in here to answer this?
Yes, ma'am, sure, go ahead.
Trish, are you in here?
See, so the way that the bill reads is it says it's unlawful for a clergy member to engage in intercourse or sodomy with a child under the age of 19. And the way that this bill has been drafted, if whoever falls under the position of clergy member would be responsible if they are in a position of trust or authority over that child. The bill originally said over a child, and I asked if she would be willing to amend it to put over the child. So it wouldn't just be, you could be a pastor or clergy member over any children, and then if there's a girlfriend or boyfriend situation over here, if you're not in a position of trust or a position of authority over that person, it would have to be someone you are in a position of authority over. So if you were a pastor and your girlfriend was at another congregation, or you were not in a position of trust or authority over that person, then it would not count. It just depends on if there's that position or trust or authority as how I read the statute.
Mr. Simpson.
Okay, so just to kind of help clarify, and I think this example may be to help benefit. If you're a 19-year-old in charge of the nursery, you would be in charge of that child in the nursery. That would be the relationship you're talking about. But if you're a 19-year-old in charge of the teenage group, you would be in charge of that child. However, a 19-year-old that is not in charge of the teenage group that has a relationship with a 17-year-old in that teenage group, if that 19-year-old is the one that works in the nursery, that's not the issue. That won't be a problem, correct? They're only supposed to be responsibility for the authority of that child.
Yes, that's why it was changed from a child to the child, to make sure that there was that actual position of authority.
Okay, Mr. Robbins.
In looking over the bill, it still says a child. It doesn't say with the child.
It's in the amendment that Representative Simpson brought.
His amendment amends lines 56 through 58 and defines clergy. It redefines what clergy is, but the bill itself, unless there's another amendment.
So, hold on one second. So, let's see.
Right, but that's in the amendment of the.
So look at, on page 1 of the amendment, line 17, it says of trust or authority over the child.
Right, but what I'm saying is if you look at line 62 and line 67 and 68, the code section would read 13A686. If you read that section, it would still say with a child. And section 687 would still read with a child. So the definition of clergy would say with the child, but then when you read further down in the code section, it says with a child. So
I think that's easy to fix with the same amendment of changing that if y'all.
We would make an additional amendment.
Let's get it.
Let's get it. On
just so the language,
62,
the language tracks.
and what else?
So we would need line 62
and 68
and 68.
Just delete the word a on both of those and put the
word the.
You want it written, or y'all want it?
Put it on that one again. And that way, just.
What about line 84 and line?
Yeah, we should do 80. Yeah, we should do 84 too, because that's 84 and. I don't know about 85.
I don't know about 84.
No.
Y'all tell me.
The way 84 reads as far as distributing, transmitting obscene material,
Yeah.
I don't care if it's the child or any child.
Yeah, I agree. I agree with Representative Simpson on that one. It's unrelated to the matter which I think what the bill is about. That's about distributing child pornography, basically. So I think, you distribute any child, and then 85, I agree that we don't need to change that. It's just, that's soliciting a child to transmit. Yeah, we 84, 85, let's not touch those.
For purposes of your bill, do you want it to read the child or that child? Maybe we ask
I'll take the amendment and say, I would say
The child.
in 62 and 68.
Yes.
So the way it'll read is on page 3 at line 62 and line 68, place the word a child with the child. Is that good?
That's what I would offer.
All right, there's an offer to, that amendment's being offered by Mr. Simpson as a second amendment.
I have a
There's second. Yes,
Can
ma'am.
we clarify, so I am on the exact same page with y'all. We are only changing 62 and 68 and we are leaving A, because I do want to leave it A on the other two. That's what the amendment is? Okay.
Yes.
All right, thank you.
Okay, all in favor of the second amendment, please say aye. Aye. Any opposed? All right, now we will accept a motion to give this a favorable report as amended twice. Go ahead, Mr. Partner. Thank you. Second, okay, thank y'all. Any further comments? All in favor, say aye. Aye. You got a favorable report. I tell you what, though, Ms. Halsey, it's a heck of a note that we live in a society where we have to worry about this kind of stuff in a committee meeting, isn't it?
I agree. I agree.
Be that as it may, I'd rather worry about it here than worry about it on the street.
Yes,
Okay.
sir. Thank you so much. I appreciate
You're
it.
more than welcome. Representative Inslee, you've never been here before. You sure you want to come up?
I'm glad some others warmed it up for me. Thank you, Mr. Chairman and committee members. Good to be here. Here because they're, for the first bill, pretty straightforward. I've heard from letter carriers from the post office in my district and throughout the city that are increasingly under threats and assaults when they're delivering mail. Some of them are here today. So this simply makes a change where letter carriers would be considered with a long list of other people that interact with the public, that it would be assault in the second degree. So I asked for a favorable report.
Okay. Yes, sir. Okay, I'm sorry. Mr. Wadsworth gives us a motion. Mr. Pettis a second. Any questions?
I have a quick question.
Mr. Betzel, please.
And I may have not seen it here, but do we have a definition of letter carrier? I certainly understand the intent here, our United States postal workers, but we have a lot of other carriers out there. Does this apply to everyone or just those individuals?
The great question. We did just say letter carrier. We didn't specify as postal service. If we wanted to amend it to say that, we could, but it does just say letter carrier without a definition.
Okay. And my apologies for not thinking of that sooner. I'm certainly still favorable of what you're doing. I just think maybe we could define that to meet the intent so we're not too broad with that.
Sure. No, I'd be fine with that if we can do that on the floor.
We can, or we have our expert back here. and let me ask you a question. Hey, Ray, after the word letter carrier, can we put a parentheses and say postal?
It cites to a code section 326380, and that's what I'm pulling up, and it does define letter carriers used in this division. Somebody who's employed by the United States Post Office, employed as a letter carrier. So it does cite to a specific definition of letter carrier.
Okay.
So I'm not going to do an amendment on it. But I will if you want me to.
Our analyst is happy.
Sounds good.
All right, there's a motion and a second. Any further discussion?
Just to be clear, and I'm supportive of your bill completely. This would put that parameter on United States postal carriers, not like an Amazon driver or UPS driver or some of those ones.
Correct. And I think under the code definition, right, it does just, from what I'm hearing correctly, it says just United States Postal Service.
Right. And that's what the code says. So I just wanted to be clear for everybody through there.
Okay, all in favor of favorable report, please say aye. Aye. Any opposed? Thank you, sir. Mr. Inslee, you did good. In fact, you did so good.
I get to say up here?
Yes, sir.
Great. Well, the second one has been in the news quite a bit. The term is often called swatting. On a very personal note, my synagogue has been targeted by it multiple times. And this is when someone either makes a threat or they call in a threat and says that there's either a bomb or there's a mass shooting. I know this has happened throughout the state at hospitals, schools, most recently at the Walmart in Pell City. And what it often leads to is not just one or two officers showing up, but a whole team coming, often a SWAT team, if not a K-9 team. It creates a lot of havoc, and it is a tremendous strain on those resources. The hope with this bill is to deter people in the first place from doing it, but knowing that sometimes people will still carry it out, it will impose penalties then if they do go ahead and carry out that type of incident.
Well, we got an amendment, don't we, Mr. Inslee?
We do. So there are a few just technical amendments. They're all on one page there. Do you want me to walk through them?
Yes, sir, please.
Sure. So on line 18 on the first page, we would just replace it with the following. It would say this bill would establish venue for. It currently says jurisdiction, but technically it should just say venue. The next one, line 50 on page 2, we would replace it with the following to say penalties to establish venue for violations to provide. The next one on line 83, page 3, we'd replace it with the following misdemeanor offense. The next one would be on line 95, page 4, for the purposes of determining venue. And then the last one, line 103, page 4, we would replace it with the following: order to pay restitution to any individual, agency, or entity who incurs. Right now, it just says individual, but we would add agency or entity to include law enforcement agencies or entities.
Okay, I'll offer that amendment for you. Second. Okay, any questions about the amendment? It basically just clears up your language.
Correct.
It's good. Thank you. All right, all in favor of accepting the amendment or adopting the amendment, please say aye. Aye. Any opposed? All right, I will now accept the motion for favorable report as amended. Mr. Hedda.
Question?
Yes, sir. Well, let's get a motion in a second, then I'll let you.
Oh, yes.
Is there a second? Second. Thanks, Mr. Chestnut. Go ahead, Mr. Faulkner.
Yeah, Representative Benzer, I wanted to ask you, I know our Hoover police chief, when we have our meetings with our cities before session, we had an incident up in Birmingham where someone reported seeing a child and then they went missing, and it was a huge response was out there, and it took all kinds of man hours for days, and then the person actually came forward and admitted they made it up. So did you have any kind? I know he had talked about a bill being brought. I didn't know if this would cover that, and
So this could cover some of those situations. My understanding is there's a member separately working on called, I think, the Carly Russell bill that would deal with those kind of false reports. There is overlap at times, and in that situation, it could apply here. But my understanding is will be a proposal from a different member that deals more narrowly with a false report.
We'll get that.
But this could potentially cover a situation like that if someone calls in something and it leads to a mass law enforcement response.
Okay, and then the term swatting, where is that? I'm just clueless on that. I've never heard of that term. Is that?
I had not heard of it until more recently either, but I think my understanding is because SWAT teams often have to respond to these incidents, that's why it was given the term swatting.
I think that's right, Mr. Faulkner. I'd never heard it either. I always thought it was something your mom did when you messed up.
We had a similar bill from Shane Stringer last year. What was that called? Doxing.
Doxing. You're right.
We're learning all sorts of new words.
We are. Unfortunately, we're getting more and more stuff like this in not only our vocabulary, but our society. Okay, we've got the bill. There's been motion and a second to give it a favorable report as amended. Is there any further comment? I tell you this, if you hadn't had it in your community, I'm glad. If you have, it's very disruptive. It's very, you know, Mr. Betzold, you liable to be out in the middle of it one of these days, aren't you? You really are. Okay. All right. All in favor of favorable report, please say aye. Aye. Any opposed? Thank you. Thank you, sir. Appreciate it. Mr. Brown, are you ready? And, you know, ladies and gentlemen, just on another thought real quick, as these bills are done and they are amended, they will all be put in on the floor in the amended version. Consequently, there will not be the need, as we have done in the past, to offer the amendment, offer the amendment, offer the amendment. As we've done, it'll come in at one sort of engrossed type of situation. So that'll make it easier once we get through here. Maybe make it a little bit more difficult here. It's okay. It'll be easier once we get on the floor. Go ahead, Mr. Brown.
Thank you, Mr. Chairman. Members of House Bill 21, it's the Alabama Genetic Data Privacy Act, and currently Alabama doesn't have any protections for consumers and their genetic material. When you send off to, say, a 23andMe or Ancestry.com on one of these testing sites, how they handle your genetic material after that. And so what this does, it just requires the business to post an agreement that you're aware of their privacy rules and what third parties would be handling your genetic samples. And at the appropriate time, Mr. Chairman, there's 3 amendments to.
All right, who's going to offer those for you?
Representative Simpson.
I'll offer them.
Let's do them. Can we do them one at a time, Matt?
You are the chairman, sir. I will follow your advice.
Then let's do them one at a time.
The first one is, you should have labeled as Amendment 1 in your packet. The last, it starts on line 16, replace line 164 on page 6 with the following. What this does, a genetic testing company may disclose a consumer's genetic data to any law enforcement agency pursuant to a valid subpoena. When a law enforcement agency requests data from a genetic testing company, the company shall not disclose the existence of the subpoena or the fact of the company's compliance. This is a agreed upon amendment, a friendly amendment, correct?
Correct. What this does is, I worked with Aaliyah and the state forensics to make sure that this wouldn't interfere with any solving cold cases. So this allows them to continue leading the nation solving cold cases.
Okay. All right, that's Mr. Simpson's offered that. Is there a second? Second. Thank you, ma'am. Ms. Allman. Okay, motion second to amend. Any discussion? All in favor, say aye. Okay, so it's amended. First, go ahead, Mr. Simpson.
Amendment 2, replace line 188 through 189 on page 7 with the following: a covered entity or business. And again, this is another free, agreed upon friendly amendment.
Correct. It's a friendly amendment that just protects HIPAA compliance.
Okay, thank you. All right, is there a second? Thank you, Mr. Pettis. All right, motion second. Any discussion? All in favor, say aye. Aye. All right, and the third amendment, Mr. Simpson.
Yes, the third allows for, just replace line 69 on page 3 with the following. The definitions: genetic testing company or company, any person other than a healthcare provider. And then they're defining a healthcare provider. Again, this is a friendly amendment to make sure that healthcare providers are still covered under the statute.
Okay.
Correct.
Thank you, Mr. Faulkner. There's a motion and a second. Okey-doke. Any discussion? All in favor, say aye. Aye. All right, Mr. Brown, we're back to you with your bill amended 3 times. Is there a motion, Mr. England? We got a motion to give a favorable report as amended. Is there a second?
Second.
Thank you, Ms. Allman. Okey-doke. Any other discussion? All in favor, please say aye. Aye. Okay, Mr. Brown, thanks a lot.
Thank you, Mr. Chairman. Thank you, members.
The next 3 are brought by members of our committee. Okay, you're welcome to go down there, Mr. Pettis, or I was going to tell you you're welcome to stay in your seat because we're a little bit crowded. Thank you, Mr. Faulkner. Go ahead, Mr. Pettis.
Thank you, Mr. Chairman, Mr. Meady. This bill was introduced to put leg monitors on the prisoners under mandatory supervision. When it was drafted, if you cut it, defaced it, did anything to it, was left off. What this amendment does is, all it does is add
If it shall be a Class C felony for individual to knowingly alter, disable, deactivate, or tamper with, remove, damage, or destroy any device used to facilitate, can't say it, electronic monitoring under this subdivision.
Okay. Any questions for Mr. Pettis? Yes, sir, Mr. Simpson. And there's a second, motion and second. Okay, all in favor say aye. Thanks, Mr. Pettis. You get a favorable report. Mr. England, same deal. You're welcome to go up there. You can stay where you are. Okey doke.
Thank you, Mr. Chair. Next time I'll wear a tie for you.
I doubt it, but okay. We will accept your statement of interest.
This is House Bill 29. It's in the same form that it passed this committee last year, with a lot of help from several of my Republican colleagues and also in discussions with the Attorney General's office. If you could imagine that I was able to work them all the way to neutral on this bill, and to the point that they actually suggested language that is in here. What the bill does, it creates a very limited pathway for individuals that are incarcerated with life without parole, who have been incarcerated for at least 24 years, have also, in the course of their convictions, have not harmed anyone, no sexual offenses or any homicides. And also, it creates this pathway. It's temporary. It closes after 5 years. So I think October 2029, you'll no longer be able to use that. So again, it's the same bill in its form that we passed it out of committee last year. So I'm here to answer any questions.
And you're going to offer this as to get a favorable report, are you not?
I am.
All right, is there a second?
A second.
Thank you. There's a motion and a second to give this bill a favorable report. Any questions? Comments? Yes, sir, Mr. Faulkner.
Representative England, appreciate all your comments, and I remember this from last year. I know the AG, and I've spoken to the AG's office, and exactly what you said. District attorneys, DAs, was there any conversation with them? I don't remember where. Has any objection been presented to you by the district attorneys on this bill?
Absolutely, yes. Last year, it made it through just about the entire process without any real give and take with the district attorney's office. This session, it's been a little different. They've identified a couple of issues going forward, one of which I think is the notice requirement that it puts on the district attorneys. And in the future, obviously, we'll continue having discussions to see if there's a better way or a different way to notify victims in regards to if a person who is eligible for this relief gets a hearing. So the victim will be notified, and as the legislation requires, it'll be heard from.
Okay.
Yes, sir.
Yeah, if I may, I just speak to that just a little bit. I'm aware of the same that Representative England just spoke about. I think there's some alternatives let's just go back to last year. I think that specific to me and my involvement in this is I wanted to ensure that victims had a voice in this whole matter. I think that we all agree there that if they were the victim of a crime like this, we should ensure. The $1 million question last year was left a little bit vague on who would be responsible for notifying the victims. I think the thought in the off season, so to speak, was that the district attorneys were perhaps the best prepared to do so. But upon further consideration, I think we have some options here. So I still feel comfortable with my support, knowing that we have an option to find somebody, if it's not the district attorneys, that would be responsible enough to notify victims in this case. So I think some of our concerns can be alleviated through further discussion, but I still feel very comfortable in my support.
Good. Thank you, Mr. Betts. I appreciate that.
So, and I had similar concerns expressed to me, also very, much support the bill, but it really, as it relates to the victim notification, and I know that it's a long way from where it was, but are you suggesting, Mr. Bedsole, that we might make an amendment on the floor, or are you just?
Well, it's not my bill. Please go ahead.
Right. Great comments, and it's a great question. There's, throughout the process, we ended up in a completely different place from when we started to where we ended. So as the process works, more than willing to take any suggestions or amendments in terms of how we notify the victims, because obviously that's a very important component of the bill. And there are other entities out there that do keep up-to-date information on victims, like, for example, the parole board does, because they have to notify victims in the event that somebody goes before them for parole. So there may be an avenue there.
Okay.
So if we want to figure out a way, as this process works, to remove the district attorneys from that responsibility of notifying a victim, I think there are avenues to do so.
And I don't have a good suggestion to that. I just know that that's a concern still and would like to see further discussion on it. I just don't have a good answer today.
I'll just chime in since Representative England brought it up. There's been some specific conversation with bureaus of pardon and parole, so I think that they would be very open to assuming that responsibility.
Okay. All in favor, I think we've got a motion second on this. All in favor of a favorable report, please say aye. Aye. Any opposed? Thank you, Mr. England.
Thank you, Matt.
All right, ladies and gentlemen, the last bill is mine, and since I offered to the other gentleman the same opportunity to stay where they are, I'm going to offer it to myself, and I'm going to keep it. We passed this bill in the same substance last year. This is House Bill 62. This is a bill wherein retired judges can be called back to service. This does not change the amount of money that they would be paid. What it does change is the mechanism by which they would be called. Last year, we tied it to the weighted caseload. That simply did not work. It just simply didn't work. The counties that were going to get, for example, I think Tuscaloosa got another judge. I think Shelby County got another judge. I think Madison, and I think...
We talking?
Yeah.
Yeah. All of that.
Everybody gets a judge.
Judge Becker.
I don't. Nevertheless, let me explain this. It would simplify the mechanism by which, for example, Judge Woodruff, if he needed a retired judge to get back, would simply make that recommendation to the Chief Justice, and between them, they could allow that to go forward. It'll work. This will work, I think, in rural counties more than urban counties. My experience on the bench was that about half of my cases were domestic, and those were oftentimes the most difficult ones to get to a hearing. So I'm going to make a motion we give this bill a favorable report. Thank you. Any other questions? Sir? In fact, I think it already has worked in Lauderdale County. I believe y'all have already gotten a replacement for the individual that had the issues up there. I believe that's right, Philip. I believe I talked to the Chief Justice this morning, and that has either been done or is in the process of being done. Okay, I tell you, I talked to the Chief Justice. So, all in favor of a favorable report, please say aye. Aye. Any opposed?
Comment?
1 hour. Yes.
Comment. Mr. Chairman and Judge, at the risk of my bills ever getting before this committee, I do think it's important to note, I rarely comment on the attire of committee members, but there is a legendary outfit, really a sport coat, known as the purple coat, that you are wearing at our first meeting of the year, this session, and I just want to say that coat needs to be, at some point, we will need to hang that and retire it. Like a retired jersey, not because the coat needs the material, but to honor it.
Thank you.
Is the purple coat.
Thank you very much, Mr. Partner. I will make sure to point out to Susan what you think of the coat she picked for me to wear today. We are adjourned. Thank you.
Take it to the right.
Thank you.
are you, Jeff? You're talking to. Hey, Judge, I'm Casey Day. Casey Day? Yes,